In our discussion of the Second Amendment, we're very fortunate today to have Professor Adam Winkler, who is a professor of law at the UCLA School of Law, and frankly, one of the nation's just leading experts on how the Second Amendment works, what the courts have said about it, and what the effect of those rulings might be on different gun laws. So, Professor Winkler, thank you so much for talking with us today.
Thanks so much for having me.
Well, it's our pleasure. And I'd like to start off by asking you, as you know, in 2008, the Supreme Court issued its first ruling in almost 70 years on the Second Amendment, a case called District of Columbia versus Heller. Could you start off by telling us sort of what happened in the case and how did we get to the Supreme Court in that case?
Sure. District of Columbia against Heller involved a lawsuit brought by a security guard named Dick Heller, who lived in Washington, D.C. And although he had a gun to protect the judges at the courthouse that he worked, he was not allowed to have a gun in his home for personal protection. Dick Heller lived in a high crime neighborhood, but under Washington, D.C.'s law, it was illegal for civilians to have a handgun in their home for personal defense. Dick Heller filed suit against the Washington law, arguing that it violated his Second Amendment right to keep and bear arms. The Supreme Court heard the case in 2008, and it would become the first Supreme Court case to make clear that the Second Amendment protects an individual right to bear arms.
Well, great. Thank you for that background. That's enormously helpful. So, more specifically, what did the Supreme Court say in District of Columbia against Heller?
The Supreme Court, in a narrow 5-4 ruling, held that the Second Amendment does protect an individual's right to have guns for personal protection. In particular, the court said that individuals have a right to have a handgun in their home for protection. And the court left open other questions about the Second Amendment, such as whether you have a right to carry a gun in public or what kinds of guns you can have. But nonetheless, the ruling was important because it touched off a wave of lawsuits on the Second Amendment.
So, the court limited its ruling, at least initially, to having a handgun in the home. How else did the court limit its ruling?
Well, the Supreme Court was careful in its ruling to say that there's plenty of room for state and local governments to pass gun control measures. The court said in a very important paragraph that nothing in the Second Amendment or the Supreme Court's opinion should be read to call into question laws that ban felons from possessing firearms or restrict firearms for people with mental illness or restrict guns from sensitive places such as schools and government buildings. And indeed, citing that paragraph, many courts have upheld a wide variety of gun control laws.
So that's a wide variety of gun laws that the court said shouldn't have doubt cast upon them. And as you've said, the lower federal courts, after Heller was decided in 2008, began to hear case after case challenging all different kinds of gun laws. What's been the trend there? How have the lower federal courts responded to those allegations that a wide variety of federal, state, even local laws violate the Second Amendment?
Well, the lower courts have ruled on over 1,000 challenges to gun control measures under the Second Amendment in the first decade after the Heller decision.
Wow.
And the vast majority of those cases uphold the challenged laws. In fact, lower courts have upheld laws ranging from restrictions on felons possessing firearms to restrictions on concealed carry of firearms, restrictions on open carry of firearms, and restrictions on military-style rifles and high-capacity magazines. However, not all of the lower courts are uniform in their assessment of these laws. And while the vast majority of gun control laws have survived, there remain judges who call into question gun laws that are on the books today.
So that tells us where we are now, and so I would ask you to gaze into your professorial crystal ball and tell me what you might see coming for the future. What kinds of questions has the Supreme Court left unanswered, and do you expect them to try to answer them soon?
The Supreme Court has left the vast majority of Second Amendment questions open. The court, for instance, has yet to rule on whether you have a right to carry a gun in public. And if so, what kinds of permits can state and local governments impose on those who want to carry firearms? and the Supreme Court has not made clear which kinds of firearms can be prohibited, such as things like military style assault rifles. So there are plenty of questions that remain to be answered. How the Supreme Court will rule on those issues is not certain, while courts have, over the course of American history, generally stayed on the sidelines when it comes to the right to bear arms, allowing laws to go into effect that have only reasonable burdens on gun owners, but don't prohibit them from accessing firearms if they're a law-abiding citizen. But with the Supreme Court could be turning in a more conservative direction as a result of some recent appointments to the Supreme Court by President Trump. And those justices seem to be more likely to be strongly pro-gun in reading the Second Amendment.
I understand that the Supreme Court, in fact, has agreed to hear its first Second Amendment case squarely on the Second Amendment in almost a decade. Can you tell us anything about that case and what we might expect and when we might expect a ruling?
The Supreme Court has agreed to hear a challenge to a New York law. New York requires you to have a permit to have a gun in your home, and then says if you have such a permit, you can only take your gun to a very limited number of places, such as certain gun ranges. This law has been challenged by a group of people who have these permits but want to take their guns to other gun ranges or to take them into other states, but New York law prohibits that. The Supreme Court could strike down this law without having a big impact on gun policy at all, because it is a rather unusual law that New York has. No other state has such a law. However, it seems likely that the Supreme Court may well take the opportunity to articulate some broad principles for how we, the people, should understand the Second Amendment.
Well, we'll have to wait and see what the Supreme Court does. Where does this all leave you? Do you feel optimistic or more pessimistic or cautious about the future of the ability of the federal government and states to enact the kinds of gun laws that can help to reduce gun violence?
I think it is possible that the Supreme Court will put a check on gun safety advocates who push for very aggressive reform. At the same time, I think the story of the Second Amendment has always been less a story about the Constitution and more a story about politics. The NRA and pro-gun forces have been very, very powerful political voices in America, and that's why gun rights are so strong in America. If we see over the coming years a revitalized gun safety movement, as it seems to be happening in the wake of the Parkland shooting, then we may find that there's more political will for gun safety regulation, and the Supreme Court will likely fall into line.
Is there any closing words of advice that you might want to offer to the students of this course with regard to the Second Amendment, and maybe when they are talking with a member of the legislature and that person says, well, are we allowed to do what you're proposing, or does the Second Amendment prevent it?
Yes, I think that people who watch this course should be mobilized and activated to go do something about the problems they see in their community. And I think that that kind of political activism has always been central to victory in the gun debate. In recent years, as I mentioned, the NRA has really had most of that political momentum on the pro-gun side. We are seeing more momentum on the gun violence prevention side, and those activists should be able to go in and say, hey, to lawmakers, the Supreme Court has not read the Second Amendment to prevent us from adopting reasonable regulations that promote public safety and can't do more to keep guns out of the hands of people who are not trustworthy.
Well, Professor Winkler, thank you so much for that note of both clarity and hope, and we'll have to see what the Supreme Court decides, presumably later this year, perhaps early next year. But thank you so much for taking the time to talk to us and our students, and we will look forward to reading your future work and scholarship on the Second Amendment. Thank you.
Thank you.